Hello, my name is Michael Tesoro, and I prepared this ACCC video note entitled Telstra Dodges Mega Penalty for Mega Dumb 5G Play. I know that sounds like a bit of a harsh title, but I think once you've listened to the presentation, you probably agree with me that Telstra's play in relation to this matter was pretty dumb. Bit of background about myself. I'm a competition and consumer lawyer, and I've been running my own practice, Tesoro Legal Consulting, for the last 14 years. And in that time, I've helped lots of companies with competition and consumer law matters. Prior to that, I worked at the ACCC for 15 years in a variety of roles, including as a Director of Enforcement. The outline of the presentation, I'll start with some background, then go through a chronology, then discuss the major features of the undertaking entered into by Telstra, discuss the conduct they engaged in, and finish with some commentary. Now, the first announcement of the case came with the release of this media release by the ACCC on the 3rd of August 2022. And as you can see, the ACCC accepted a court enforceable undertaking, a Section 87B undertaking from Telstra, to address its competition concerns about Telstra's registration of radio communication sites in low band spectrum, which is a 900 megahertz spectrum, which they believed interfered with Optus's planned rollout of its 5G network. And as you can see in the next paragraph, the ACCC conducted an intensive investigation and developed concerns that Telstra's conduct had been done for the substantial purpose or likely effect of preventing or hindering Optus from deploying its 5G network. So effectively, it goes on and says that Telstra engaged in conduct which was aimed at substantiating competition in the retail mobile market. And the undertaking entered into by Telstra was seen by the ACCC as ameliorating these concerns about competition by forcing Telstra to deregister these various radio communication sites. Now, the media release goes on, and I think this first paragraph is quite an insight into the ACCC's thinking. It says there, Telstra's undertaking promptly addresses the ACCC's competition concerns and stops likely harm to competition and consumers quickly. It is an efficient and effective way to achieve a positive market outcome. So I think the words there about promptly, quickly, and efficient and effective, what the ACCC is saying there is that they had to balance up whether to take legal action against Telstra for a breach of the legislation, which would have taken a number of years to resolve, or whether to accept an undertaking from Telstra that would restore the competitive position of the market. And while I think it was a difficult decision for the ACCC to make, it obviously opted for the more pragmatic solution, which was to settle the case with Telstra and have all these sites deregistered. So it is an interesting case, but I think it's a pragmatic outcome by the ACCC. Just go through the details now. Now, the chronology starts pretty much in 2016 when Telstra closed down its 2G network. And what you should remember here is that even though Telstra had a lot of 900 megahertz band, it didn't use it to register any sites after 2016 until January 2022. So effectively, this spectrum lay dormant in Telstra for 6 years before being reactivated in a pretty big way in early 2022. Relevantly, between the 30th of November and the 6th of December 2021, ACMA conducted an auction of spectrum licenses in these low band frequencies, 850 and 900 megahertz bands. And these bands were scheduled to commence operation from the 1st of July 2024 and operate for a 20-year license period. And Optus was a successful bidder for acquiring all of the 900 megahertz spectrum that was on offer. Then in 2021, ACMA announced to all the successful bidders that they were able to apply for a PMTS Class 8 apparatus license, which would effectively allow them to use their spectrum earlier than 1st of July 2024. So these were called early access licenses. So On approximately 8th of December 2021, Telstra became aware that Optus would be seeking to apply for early access licenses to start using its 900 megahertz band spectrum prior to July 2024. So competition would be starting up in the market a couple of years earlier than had been anticipated. Then on the 31st of January 2022, Telstra rushes out and registers 315 sites in the 900 megahertz band. And this is after, as I said before, many years of inactivity in these areas. And the areas that were being registered were these prime locations with large populations, capital cities. So particularly the types of sites that Optus would be very interested in setting up its own 5G network. So the ACCC, I believe, at that time commenced their intensive investigation, and Telstra responded to that investigation by quickly deregistering a large number of these 315 sites. And as you can see, by the date of the undertaking, 3rd of August 2022, Telstra had deregistered 153 of the sites which it had registered only a few months earlier. But that still left 162 sites registered. So the undertaking that's been entered into has been offered to address the ACCC's concerns about the impact of registering these sites. And the undertaking is to facilitate the deregistration of what they call the remaining sites to the extent necessary to remove barriers to the Optus rollout of its 5G network using the early access licenses. The procedure by which this will happen under the undertaking is that Telstra has to appoint an independent accredited person whose role it will be to identify the sites which have to be deregistered, and also ensuring that Telstra doesn't seek to register any new sites going forward that might interfere with Optus's 5G rollout. So the process will be that Optus will advise the approved person of two things. Firstly, that it has applied or proposes to apply for an early access license in relation to a specific site, and then that it intends or is in a position to commence using the relevant spectrum at that site within 4 months of the date of notification. So both of those issues or requirements are met, then AP, the approved person, will direct Telstra to deregister any sites which it has which are within 50 kilometres radius of the proposed Optus site. So it's a simple process really. Optus will tell AP where it's proposing to set up a site, and then the approved person will direct Telstra to close down any sites or deregister any sites which are within 50 kilometres of that proposed Optus site. The only exception is in relation to any pre-existing sites, which are sites that were registered by Telstra prior to the 30th of January 2022. There is a further undertaking in clause 15 of Annexure A, whereby Telstra has to advise the approved person of any new or additional sites. So effectively what happens here, Telstra lets the approved person know if they want to set up a new or additional site, and advise the approved person whether it's going to cause any interference to a current or notified Optus site. And if it is going to cause any interference to an Optus current or notified site, the approved person will not approve it. However, there's no risk of any interference, then the approved person will allow Telstra to proceed with the registration. Some further undertakings in clause 16 of Annexure A, where Telstra undertakes that it will not, before 30th November, register any sites under any existing PMTS Class B apparatus license which is located within 50 kilometre radius of a remaining site. So this stops Telstra from setting up new sites in a near location to an existing site. And I guess the risk of Telstra being able to do this is it could undermine the efficacy of the undertaking. Furthermore, they're not allowed to apply for a license to use this 900 megahertz band at any site which is located within 50 kilometre radius of a remaining site. And finally, it cannot register any radio telecommunications sites which are not a remaining site. So this is further obligations to just ensure that Telstra doesn't seek to engage in more conduct which has the effect of interfering with Optus's 5G rollout. The further undertaking, which is interesting, is that there was a requirement for Telstra to provide executive CCA training, which is obviously Competition and Consumer Act training. And this training has to be provided to very senior people in Telstra, the CEO, members of the CEO leadership team, the board of Telstra, the group executives in network and IT, and then any managers who have a role in the implementation or development of spectrum strategy. Now, just turning to the conduct, in the undertaking, the ACCC sets out its concerns in the following way. It's concerned that Telstra has used its substantial degree of market power in the market for the supply of retail mobile services to engage in conduct which had the purpose or likely effect of hindering Optus from effectively rolling out its 5G network by registering all these different sites, and further that the Telstra conduct had prevented Optus from engaging in competitive conduct. And ACCC concludes that this was a breach of Section 46 of the Act. So effectively, the allegation is that Telstra misused its market power to substantially lessen competition in the national market for the provision of retail mobile services. And this is a very serious allegation that the ACCC has made, and it just shows that the ACCC believes that this was a conscious strategy by Telstra to interfere with the Optus rollout of its 5G network. And just some commentary here. I guess the first issue is that this was a very clear breach of Section 46 of the Act. Telstra implemented a clear strategy to register sites to interfere with Optus's plans to roll out its 5G network using the early access licenses which were available. And it did so by registering sites in the most populous areas of the country that would have been prime areas for Optus to seek to exploit with its 5G network. And the clear way that this breached the Act is beyond question. The more concerning issue is who made the decision to engage in this conduct. This is not the kind of conduct that a low-level employee in Telstra decides. If Telstra is going to engage in a process of quickly registering 315 radio communication sites across Australia, then this is clearly the decision which goes to the top levels of the organisation. So you have a situation where the senior leaders of the organisation, and I think there's a very strong inference that this decision was signed off at the board level. So a decision has been made at the senior levels of the organisation to engage in what is a very clear breach of Section 46 of the Act. It's quite remarkable that people of that seniority, who have no doubt had compliance training, who regularly receive updates about competition law issues, should engage in such a dumb play. Really, there was no way, firstly, that this conduct was not going to be illegal, and secondly, there was really no way that the ACCC was not going to find out about this conduct. Now, the lucky break for the Telstra, and I think for a lot of its senior executives who must have been engaged in this conduct, is that the ACCC was faced with two options: whether to take Telstra to court and run the case, a breach of Section 46, which I have no doubt it would have been successful in winning. And not only would have won the case, but it would have obtained an astronomically large penalty. There's no doubt that had this case been run, the ACCC would have obtained a penalty of a huge amount, which should have dwarfed any other penalty awarded under the Competition and Consumer Act. And it would have, I think, invariably taken action against a number of senior executives and other people in Telstra for their role in this particular strategy. But the ACCC had to balance up that with the need to try to get the sites deregistered to facilitate the rollout of Optus's 5G network. So what the ACCC decided to do was pursue that option, which would result in a quick and effective opening up of the market, would allow Optus to continue its rollout strategy and thus advantage competition in the market. So it's just curious whether the conversation between Telstra was along the lines of Telstra spelling out to the ACCC that if it did seek to take legal action in relation to the matter, the case would be dragged on for a number of years and the conduct would not be remedied. Alternatively, the ACCC could agree to Section 87B undertaking where Telstra unwinds all of its illegal conduct immediately and therefore the level of competition in the market is restored. And it seems to me that the ACCC chose the latter option. It can't be criticised for that. It was a difficult decision and it must be frustrating for them to let such a big, clear-cut, blatant case go. But ultimately, I think the decision it's made is justifiable. Now, as I said, the ramification of litigation would have been enormous. There would have been an incredibly large fine, and I think a number of senior executives at Telstra would have been in the firing line. And I think it's a bit of a wake-up call to Telstra because it can't keep engaging in such conduct in such a blatant manner and expect to dodge a bullet. And really, in this particular case, it is quite remarkable that given all its compliance networks and systems and programs, that something like this could get through all of those checks and balances. So I think it's time for Telstra to get serious about compliance. It may be time to hire somebody to come in and review the way their systems work and get to the bottom of how something like this was able to make its way through the whole organisation and be implemented. So just in conclusion, I think you'd have to say that Telstra did dodge a bullet in this particular case for engaging in a very, and I'll probably use the pun again, engaging in a mega dumb play. So that's all I have. If you have any questions about the presentation, feel free to give me a call or drop me an email. Bye-bye.